once I'd seen all this stuff and talked to the realtor, I wrote a letter back to this person who was complaining and said, thank you for your letter. I act for these people. As to liability, you'll notice that the MLS listing sheet has a disclaimer at the bottom, and the Victoria one actually is better than the one that you guys have. I always wish that everyone would adopt the Victoria one. You guys have the one, I think, that says all the information is...
While deemed to be correct is not guaranteed.
Yes. Victoria goes further with another sentence and says anything of importance to the buyer should be verified by them. Kind of like the language you find in the PDS, right? And it's just better because it appears then on the MLS. And before I forget, because I always have these tidbits and then I regret because I'm driving home or to the office when I think of them. Why not put that on your brochures? Something similar. Because a lot of clever claimants, what they'll say is, oh, I wasn't relying on square footage or the age of the roof from the MLS listing sheet, because clever, they see there's a disclaimer at the bottom. They say, I was relying on it from your glossy brochure, and there's no disclaimer there. So if you're going to produce marketing materials or little floor plans, or make sure you put a little, even if it's just that language, no more, some little blurb that says, watch out, this could have an error in it. If it's important to you, square footage because you're claustrophobic and you can't have a condo of less than 1,000 square feet or you'll be in the hospital. Put something on it. And I've seen some clever plaintiffs kind of try and do an end around the MLS listing sheet with a disclaimer. Anyway, so I finish off that section of the letter by saying if it was important to you, you should have verified it. And then I go on, and as to damages, you don't get the cost of a new sprinkler system. Arguably what you'd get is the cost of a 22-year-old sprinkler system because it was old and maybe it was about to break, and like an old washing machine or something like that. And I said, but furthermore, that's not the test at all. The test is the difference in value of the property at the time of purchase versus what you paid. So did you get what you were paying for? And I challenged them to find an appraisal of the property at the time of purchase showing that $1 million property is worth less without a little garden sprinkler. And I never heard from them again. So would have been an easy case for someone to say, I'm not going to see my owner or manager, I'm just going to admit fault and throw myself on my sword, give up part of my commission, which we can't advise you on, or come to E&O and ask them to write a big check. And there are sometimes defenses that you're not aware of, and there's quite often damages defenses you're not aware of. Anyways, so that's the ones where it's a letter or an email, and sometimes they go away and sometimes they don't. And if they don't go away, what they tend to turn into is court claims. So someone starts something in small claims court up to $25,000 or beyond $25,000 in Supreme Court. And that's very serious. We certainly want to know about all the claims generally, but we want to know about litigation immediately because there's time running. They can get a default judgment. If you're served with it and you kind of put your head down because you don't want to think about it and it's stressing you out, you don't tell your manager, you don't tell us, you could actually have the 14 days to reply in small claims or the 21 days to reply in Supreme Court. You could have it expire. And if that happens, what I usually say to the person is, you go hire a lawyer to set aside that default because you put your head in the sand, and if they're successful, I'll then look at it for coverage. Because it's not my fault you put your head in the sand. We try and be helpful, but if someone's put their head in the sand, that's their problem. So 38% are not in litigation. Those are the ones where we're writing nasty emails back and forth or letters back and forth. Or sometimes we've opened a file because someone's just started chatting about how you're naughty, but hasn't actually done anything that I can respond to. It's hard in those cases where there's nothing in writing, because what am I going to write to the person? I hear that you're maybe mad at Alan, and maybe you think Alan did this, that, and the other. You haven't said anything yet, but if you do, believe me, I'll say this on behalf of Alan. It's a silly letter I can't write. So sometimes we'll open the file and just wait and see if the claimant wants to get legal advice, makes a claim, because sometimes they'll go see a lawyer who actually practices in this area, who will tell them that, oh, there's a disclaimer, and oh, the PDS can only be relied on to a point, and it's a very small point. And, there's no damages anyways, even if there was an oopsie. So sometimes they don't go anywhere. But the rest of them, there's about 47% of the open files are in Supreme Court, so over 25,000. So we're seeing sometimes less claims, but we're seeing higher value. And then 15% are in small claims court. And we handle, almost 2/3 of them in-house. The rest of them we farm out to outside lawyers,
Kelly Murray.
Scott and Kelly Murray and these guys that everyone's familiar with. And they're great, and they've done this work longer than we have in many cases. Now, what type of claims? That's another thing people want to know. Well, why and how and when are we getting in trouble as realtors? Negligent misrep is by far the biggest. I've seen a lot of negligent drafting lately, to be honest. Not a lot, probably not more than 18%. It just seems to be a lot of the ones on my desk. Now, negligent drafting is just, I forgot a clause in the counteroffer, I didn't transpose it through, or I got the date wrong or the price wrong. And I can tell you, those happen. They happen to everyone. They happen to lawyers. I've offered 50,000 when I meant to offer 5,000. That's why I don't use decimal points anymore. I've just eliminated them from my life because it's just too hard to keep track of. But what happens when those occur is quite often, unfortunately, I think it's the buyer's agent sometimes elbowing their buyer to take advantage of that situation. Maybe not telling them to get legal advice about whether they should or shouldn't take advantage of that situation, but I see that quite often, saying like, oh, they've accepted our offer for lower than the asking price when they knew that they wanted more or whatever. Or they've missed to now it's closing in December 2016, and all the emails, all the discussion was about December of this year. But it was a January 16 counter, and then it didn't get carried through when they changed it back to December, so it stayed December 16. And again, you see a lot of people taking advantage of that. Quite often they're common sense, and that's handled often at the managers and owners level. When you bring it into them, they'll call up the other manager and owner who they know quite well and say, come on, let's be real here. Do you want to go have a pissing match and close in 11 months? Is that really what your client wants? Or do you want to just get on with it? And quite often they do settle, but they don't always. I had one where, just recently, where they sold, we have about one a year where the property sold twice because they forget to put the clause on a counter that's subject to not being bound to the first offer anymore. Somehow that gets lost in the shuffle. So it ends up that buyer one accepts and buyer two accepts. Well, they only have one property. And in those cases, again, they're going to sell probably to one of the two buyers. Then the other buyer should go and mitigate by buying another property down the street. And hopefully not too much because they'll look to us for the difference. And then we'll be negotiating that. But negligent misrep are by far the biggest, and they're mostly things, structural covers a lot, and I'll see what that is. I don't know what that is. Boundaries and soil, that's oil tanks and such, septic and sewer, building size, I'm just reading this out because it's pretty small. Leaky condos don't officially exist according to the provincial government. We still have claims where people say their condos are leaky. I don't think they mean in that scientific sense that with the building envelope, they just mean any water that comes in a condo, the claimant's going to call it a leaky condo. Title issues, but boundaries and soil, we have a lot of oil tanks. Structural, we have a lot of issues with things anywhere. Structural could be electrical problems, grow-ups, roof, windows, who knows what. And a lot of these come from the negligent misrepresentation, or basically they're saying you misrepresented the property, the seller likely as well, and you as listing. And they'll throw the buyer's agent in there as well, because they'll say you should have known that there was this problem. Now there's a spectrum to these ones. I like to get the ones, actually I have a trial in January for a week about perimeter drainage. And not perimeter drainage that had just been done such that my dual agent could have got a warranty or some papers for it. It had been done 10 years ago or whatever when the house was built, so presumably done in a way and approved by the city, who's also a defendant, and approved in the proper way. Those ones I like, because hands up in anyone in the room who has x-ray vision. Nobody. So you can't know, unless there's some red flag, that there's anything wrong with perimeter drainage, right? The one thing that can make a red flag though, and I have had this case, is I had someone where the listing agent kind of repeated the seller's representation that the perimeter drainage was done in 2009. And anyone, I think, is going to read that as perimeter drainage done. And they didn't bother to ask for any of the warranty, and I guess the buyer side didn't ask for it, any warranty papers or whatever might be in existence. And it turns out that it was a small section of it done, and I guess cleaned, because the bill was, sorry, it wasn't even a small section. It was just clean. It was $300, and I know that's what mine costs, every year or two when you get it cleaned out. So had they asked for that paperwork, I think they would have probably said, wait a minute, it's not $300 to read perimeter drainage. I don't know what it is, but it's not that. And then it would have been a red flag to them. But absent any red flag, again, you're not going to know what's in the ground. There's no reason to doubt whether it's working or not working. There's no reason to know that there's mold and rot inside this wall, any more than a building inspector can know, because all you can know is what's logical and what's visual. So in that case, I'm happy to have that case. The other end of the spectrum on things is, I don't know, maybe even a grow-up. Now, it's hard for you guys to know where there's a grow-up and where there's not, but you know, there's some inkling maybe if you see the electrical boxes tampered with, there's wires hanging out, there's moisture everywhere, and there's rings all over the floor in the basement or the garage that used to maybe have pots in them. And you see a few pot plants lying around. I mean, you know, that's the other end of the spectrum. And on a structural, or maybe that would be other misrepresentation, or a neighbor comes by and says, hey, you should go talk to the RCMP. They were here 3 months ago on this property. And again, trading in rumors isn't always the best way, but if you've gone down and checked at the city and there's a bylaw infraction notice, well, you know, that's something obviously you'd have to disclose. But those are easier, or the, you know, the age of the roof or something like that. You know, some of these ones are easier to check or not check than the ones that are kind of invisible. But that's some of the problems people get into. Here's some 2014, we were able to break them down a bit. Grow-ups were only 2%. Bug infestations, somehow, again, we can't see in the walls. I can't know whether there's ants inside this wall. I can't know whether there's asbestos. I can't know whether there's leakage and stuff. Unless there's some red flag or some reason to doubt what your seller's telling you, that's probably reasonably safe, unless there was some reason you should have known. Miscellaneous, I don't know what that is. Drainage and water ingress is a big thing. And again, the seller might not know about it themselves, so they might not know what to tell you. And as buyer's agent, you just tell them to get an inspection, and then you can rely on the inspector, which is what they should do, because you guys aren't inspectors, contractors, or engineers. And again, that sounds like throwing your client under the bus, well, but it's good advice for them, right? Because that way they have protection.
So those claims were from people that did not have inspections?
No, a lot of them do, and a lot of the inspectors miss these things. But there's case law that says if a person has hired an inspector, reliance shifts from the realtor, either of them, to the inspector. So it's always good to have an inspector. It covers your client, because 9 times out of 10 they do find these issues if they're visible. You know, if they're not latent and hidden in the wall, because they can't open walls either. But it also covers you, because if they want to complain down the road, you'll say, well, I recommended 3 inspectors, they chose one, the inspector came, inspector didn't see this stuff, how the heck could I see this stuff?
So when recommending an inspector, I'm assuming that it should be in writing versus just verbal, because they could come back and say, well, you never told me to hire an inspector, even if you recommended 3.
Yeah, I mean, you could have a standard email kind of stocked and ready to go for all your clients, or part of your promotional stuff, either for a buyer or whichever, could have that stocked and loaded, and you could have 5 inspectors listed, 2 notaries, 3 lawyers. I've seen people with those types of sheets, and that's just what you hand over. That way you're not recommending someone one way or another, because I do have a couple cases where they say, you only recommended one, and that inspector screwed up, and that's your fault. There's still some pretty good defenses there, because they're still an inspector. But I know board and council wants you to do 3, I think. So always meet the 100%. Don't shoot for my 51%, because you might, so not much wiggle room there.
If you've recommended an inspection and they choose not to have one in order to get their offer accepted, are you still liable?
Maybe. What I'd like to see in a perfect world is about 3 things, and it seems a bit heavy-handed. Obviously, if they have an inspection, sometimes your offers will have an inspection clause, and it's your own buyer who's crossing them out because they want to make it subject-free or less subjects, especially in a bidding war or something. And they're stroking all these out, and they're putting their initial. And that's a good start, because you'll say, well, here's a contract. I wrote in 4 conditions, there are 5 standard ones. They crossed them out right then and there. They didn't want them. But they're going to say, my realtor told me to. They'll say, oh, you don't need inspections on condos. Or, oh, you don't need an inspection on this. It looks like a wonderful property. It's very well taken care of. They'll always say that. So the next best thing is to have, and I've seen some places, and I don't know whether you guys have it, a condition waiver form. Some of the brokerages have some standard 1 or 2 paragraphs that says, I've had this explained to me that there's this condition, and I understand and I waive it of my own free right or something like that. I've only seen them a few times.
The consequences of everything.
Yeah, I mean, that's absolutely ideal. The next absolutely ideal thing is, how many people have a smartphone? Nobody?
Everybody.
Everybody has a smartphone. And what you're doing in the rare lulls in your day, especially sitting at an open house on a rainy day and no one's coming by, is you're taking care of work after you maybe play Angry Birds, you're taking care of work on it, right? So in that one where the person wants to waive their right to an inspection or doesn't even want to put the clause in the first place, I would be benefited, as would you, as would they for clarity, your buyers, with a self-serving email. Hey, heck of a Canucks game last night. I understand you don't have an inspection on 123 Easy Street. I really recommend one, as I discussed with you, but I respect your decision. Go Canucks, go. Right? Then I can call something up, and if there's not a reply email saying, nonsense, I wanted an inspection, then 3 years later I'm able to say, hey, they stroked it out. Maybe they didn't have the condition waiver form, but they also had this self-serving email, because they're a big email, big texters, and they said this. And the person, there's no response from them saying, balls to that, nuts to that, I wanted an inspection, you're an awful realtor. There's nothing like that, right? So that's probably the best 3 things that I can think of. And that's kind of another practical tip, is just to do a self-serving email. It takes, I mean, we're not in the world of letters and faxes anymore, which is a lot of hassle, I know, to get it typed up and sent and that. We're all sitting there faster thumbs than anyone on the planet. And, you know, do a self-serving email. And I can often use that in court as evidence that, hey, these guys didn't want to pay the $400 when they were buying a $2 million property. And the judges appreciate that, because I've had some judges, I had a judge dismiss a case on an oil tank, and they were actually quite critical of the people, and they were buying, I can't believe I'm saying this, only a $1.8 million house. And the judge in North Van here was very critical and said, well, did you think of hiring a lawyer? Did you think of hiring someone to look at this? Did you think of the, you know, and they were pretty critical of them. And they expect them to hire not just you guys, but they want them to be hiring inspectors. If there's roof questions, roof engineer. If there's legal questions, lawyer, right? They expect them to be hiring these people. I mean, a lot of people do more due diligence on their raincoat than they do on their property, right? They'll go out and buy a condo at lunchtime. But you guys need to slow them down and protect them and protect yourselves. And that's what all these standard clauses are all about, really. And that's what putting these self-serving emails are. You know, it protects them, it protects you. Because maybe they'll have a second thought when they see that email and say, geez, again, she's recommending that inspection. Maybe I should pay the $400 when I'm spending $2 million. Here's some other misrepresentations that we have. Encroachments and easements and issues like that. Things kind of off title, on title. Lot size, and I'll throw in building size because I don't see where it is there. We get a lot of, I thought this house was, as the MLS with a disclaimer said, 2,000 square feet. Turns out it's 1,800. And then they do the mathematical calculation of 20% of the price, which isn't the test. It's what's an appraisal of an 1,800 square foot at the time of the sale in 2011 versus what they paid, right? But that's what they're asking for. And there's defenses to that too, right? Because you'll say, you viewed the property 3 times, it met your needs, you made an offer, you weren't offering on a per square foot basis in any way, shape, or form, like you might with a new build or you might with a condo perhaps, but certainly not with a house, a resale house. And you were aware that there was a disclaimer on the bottom of the MLS. You had an inspection as well, so you're there maybe a 4th time, and the PDS as well, not that it says representations about size, but it's warning you to have inspections and that you can't rely on information as well. The PDS, remember, has about 3 different disclaimers on it, which are all to your benefit and frankly the seller's benefits as well. Fill and soil problems, a lot of oil tanks. This was just 2014, so this isn't forever. So we had a lot of encroachments, a lot of oil tanks. There's still a ton of oil tank cases out there. So for listing folks, well, either they know or don't know, and as long as you don't have red flags, like a big pipe sticking out of the ground that says oil on it, or a filler pipe sticking out of the side of the house, you probably know the signs better than I would. You know, that's probably the best that you can do. For buyers, throw in that tank clause. I'd even throw in the tank clause if someone gave me a tank certificate, if I can. It's a matter of negotiation, obviously. They might say nuts to that, I'm not agreeing to that as a seller. But, you know, try and throw it in. That might cover you off against your buyer and say, I tried, even though they had a tank certificate, because what if there's another tank underneath the driveway that the scanner couldn't see? What if the tank was removed, but they missed some migrated contamination that went over here a little bit. So now they dig it up to put in a monster home or a pool, and they find that soil. So you know, that's about the best you can do. Make sure that they get a scan as a buyer. A lot of the people will scan for free, because then they get the work, I guess, if they find a tank. I don't know how exactly they do it. But
Chris, we're getting sellers agents, trying to shift the responsibility of the oil tank onto the buyer's agent. And,
how do they do that?
they write it in the contract. that-
If a tank's found, it's the buyer's responsibility?
Yeah,
Well, that's up to your buyer. I mean, all these things are a matter of negotiation,
Yeah.
right? You don't even have to have a PDS incorporated if you don't want to.
yeah.
That's a matter of negotiation as well, and I'll come to that towards the end.
So my question is we've got this dilemma, from a buyer's agent, you want everything in favor of your buyer, and from the seller now. I mean, is that an approach we should be taking? Trying to shift it to the.
Well, if I'm for the seller, I'm gonna try and shift it to the buyer, and if I'm for the buyer, I'm gonna try and shift it back to the seller. You know, it's really a matter of negotiation. It depends how hot the market is, right? If it's a really hot market, these sellers might say, I'm accepting absolutely nothing, and I'm specifically gonna pass that, any future risk onto you, and if they accept it, they do, and if they don't, they don't. I wouldn't recommend it.
And the conflict that we have is, I think it's the fire code or whatever code shifts it to the responsibility of the owner.
Yeah, that's a statutory thing, and they might not be able to get around that, because there is for the past owners, under the Environmental Management Act, there is the past owner liability. So whether putting that in a contract absolves you of that, I mean, maybe. I haven't had that situation, so I just don't know.
Yeah, it's something that's been coming up recently.
Well, I could see it, because I see these tank clauses, and and then I'm wondering, as a seller, in a hot market with 6 offers, why in the heck are you accepting a tank clause?
Yeah.
Can you actually transfer the liability against the statute? If the statute says.
That's what I don't know, because I haven't read the statute.
I don't think you should be able to do that.
No, I don't think you can. And you may not be able to. I'll give you an example. When you guys have a complaint against you and we do a release, quite often people in the release want a release from council complaints, right? And I'll say to them, I've never done that, because I don't think A, it might give people ideas they didn't already have, and B, they have a statutory right to go to a statutory body, which is council, and complain about you. So I don't think I can contract that away in a release. So it may be something similar like that. I just haven't had the exact situation.
Yeah, but I think the statute goes, all the way back to the person who decommissioned the tank.
Oh yeah, I've seen like 5 levels in
And
the
so
lawsuit.
if the seller wasn't aware the tank was there, then I don't know if he can be held, I don't know. I think go back to the previous owner.
And they all try and say they were duly
Eventually,
diligent along the way.
You can't find somebody.
But for your buyer, the best you can do is resist those types of efforts, and it's a matter of negotiation. Maybe you go buy the next house rather than get stuck with. Because to me, if someone's trying to stick me with that, I would think, oh, maybe they know something, or maybe there's dirty soil from a neighbor's tanks even come in, and they want to, because it's usually not just the tank; it's any contamination. And I'd make sure for a buyer that you have if they hand over a certificate from the seller of a scan, get your own scan. And I would put try and put some type of negotiation in there. But it's tough. It's tough in this market too, because sellers aren't going to accept very many clauses at all. I mean, half the time they don't want financing. They're not going to want to pay for a tank if they find one. And there's a couple of really good articles in Legal Update. It was, I think, 2 years ago. Wes McMillan did a really good article on tanks and the level of contamination required in that. So if you go back, because I think past things are online now, I'm not sure. But if you go back, there's a really good article on tanks, and it's actually pretty user-friendly and as to when they have to be removed, what the criteria thresholds are, typical clauses used, and things like that. He does a really good job. And it's about 2 years ago, I think, in Legal Update. It's 13 or 14. Misrepresentation and negligence, building size, features of the home, septic versus sewer, not so much here, but I've had a lot of those cases. Boundaries, soils, oil tanks, leaky condos, title zoning, lots of grow-ups. And it's not so much necessarily the grow-up, it's what comes from the grow-up, the moldy, the having to pull out like asbestos cases where you just have to pull out all the asbestos. That's the big expense they're coming after you for. Drafting issues we talked about. Property and strata management. I won't spend much time on that. If anyone has any specific questions, they can come and ask me about that afterwards. Breach of fiduciary duty. We have this a fair bit when people are dual agent. They'll say you preferred one side over the other, as opposed to being impartial, which the dual agency contract says you must be. Or you didn't, act diligently enough in getting me my price, because there's a lot of things on price now. I find a lot of price claims, so they'll come after you as seller because they'll find out their neighbor's house sold for 50 grand more than their house did. They'll forget that the neighbor has like granite and they don't and all that. It's just, oh, I can't believe that.
Chris, have you had anybody come after you for assignments?
Yeah, we have a few assignment cases right now, and what's happening with those is sometimes they're multiple assignments too. So it's like 3 levels to get back to the original contract, and you just have to make sure you do it with a proper contract. Some people are doing assignments by just doing them with a contract addendum and saying that now Chris is on the contract. But it doesn't speak to anything about rights or legal obligations. It doesn't speak to anything about rights against the original developer or seller. It doesn't speak to anything about, well, who gets the deposit? Who's that to the credit of? What if there's a dispute and you have to fight over the deposit? Do you even have a right to it? And sometimes the price and the uplift in that isn't clear. And we have had a few recently. They're starting to happen. The other one we've had a few of recently is weirdly lost deposits. We've had about 4 or 5 lost deposit cases. Shredders, lost. If they're stolen, there's a defalcation kind of wrongdoing clause in the contract. We don't cover that. So if someone runs off with it, then the person would have to go see the compensation fund at council or the police or someone else. But if it's a negligence issue, I had the deposit, because you're deemed to have it as soon as you have it, and then it has to go under the act to the trust account immediately. And but they lost it, or Canada Post lost it because they mailed it to the brokerage. We had one like that. Fortunately, that one settled because I didn't really want to have to go after Canada Post as a third party. But there's a lot of issues with that. So we've had it's been a strange year for stuff like that. But we have started to see a few assignment ones because in the better market, everyone's trying to get an uplift. And then sometimes the one who's stuck holding the hot potato, who actually doesn't have the funds to close at all, is sitting there and then they don't close. So then it becomes more of a typical I can't close dispute, where they then blame the realtor for, what was the one I have? Not allowing access for their bank appraiser. Really, they just couldn't afford to, they thought they'd be able to assign it away and they couldn't. And it's some house on West 43rd or something like that. And bank appraisers half the time do a drive-by or do it off their computer, so that sounded like a bit of nonsense to me. I've yet to see what actually go in the house. Risk management I'll talk about at the end here. It's the practice of identifying risk and taking steps to minimize it. Identifying risk, it's what I talked about at the beginning. It's your client. Even if you love them, even if you've had them for 20 years, even if you've done 13 deals with them in the last year, that's who's going to sue you. That's who you have to be proactive with and in some measures proactive against. And that's keeping all your records, keeping all of your emails, keeping all of your texts, sending these self-serving emails, using condition waiver forms if you have them, using a buyer agency agreement. There's a lot of good stuff in that buyer agency agreement. Every time, it's very rare, only 2 or 3 times a year on a file that comes to me, that I'll see a buyer agency agreement. I always look at it and go, geez, I would never sign that. It's really pro-realtor. And it has a lot of good stuff in there. So, if you're trotting around with a buyer, why not get them to sign that form? Particularly if you're going to end up, because the main part of it was to say that you can also, how about bring other buyers to a same property? So, and that would be a breach of fiduciary duty claim. They'd say, well, if you didn't have that form signed, hey, why did you bring that other buyer? I'm in a bidding war with one of your other buyers, and you're not sharing information. Anticipate the risk, client. Shift the risk. This is to what I was talking about at the beginning, to the benefit of your own clients. And I know board and council, everyone harps on this. Get them to engage, recommend that they engage other professionals, roofers, engineers, inspectors, tank scanners, septic inspectors, lawyers. And the one thing I'll say about lawyers on this is they get off pretty scot-free on these real estate deals. They have a paralegal doing most of the work. They got some flat fee of $900 or something for the paralegal to do all the work and them to sign off on the end. And some of them are more proactive than others, so I don't want to cast aspersions on them. But a lot of them, it's kind of a factory, and they're not, getting in there. But it's one of the few times that your client gets a lawyer on a flat fee. Every other time, it's per, you pay by the hour, and it goes up, 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 up. So why not tell them if they're going to hire a lawyer anyways, get the person earlier. Because that way you don't have to, or your manager doesn't have to try and wrestle with something that could even potentially be interpreted as a legal issue. Because they'll already have a lawyer, and it'll be a flat fee of $1,100 or whatever it is, right? So why not get that person engaged earlier, particularly on a new construction, particularly on a condo, something where it might be a little more complicated. You know, maybe then the lawyer will be the one looking over the disclosure statement or looking over the strata documents rather than you.
Chris? In regards to that, quite often in the industry, we see a professional advice clause, but it's it'll basically read the buyer has been afforded the opportunity to seek independent legal advice, and as opposed to a condition precedent subject to the buyer receiving independent legal advice. Now, how does the courts look at, because typically if you say the buyer's been afforded to receive independent legal advice, normally what happens, the realtor, slides the offer under their nose, and they've had about 2 seconds to actually get independent legal advice. Usually they're not given that, it's not in advance.
Yeah, no, and in this market sometimes where, for buyers it's pretty fast acting, for sellers maybe a little slower acting, a little more time with a seller than you with a buyer sometimes on a deal. What I've seen is that, and the courts are okay with that, but if you didn't get legal advice, you didn't get legal advice. The fact that there's a clause that says you have the opportunity to, it helps. But the one I've seen recently, which is quite helpful, is that in tandem with saying, and they confirm that the realtor and brokerage do not provide anything other than realtoring advice, I can't think of the word, and specifically they don't provide any legal, accounting, inspection services or advice. I've seen that. It's like a second part to that clause, or it's its own kind of clause. I've seen that, because that confirms then that they understand, because their initials are right at the bottom of the page, presumably they've read it, and if they hadn't, too bad, their initials are on the bottom of the page, that they understand that you're not giving that advice. So that's kind of sometimes as or more powerful.
So in an unconditional contract, that would be a great term
Yeah.
to have in the contract.
Yeah, and the sellers aren't going to balk at some of that stuff, because it's just confirmations and acknowledgments, right? They just don't want condition precedents, because they want to be able to sell it for the highest amount with no conditions. You know that they've got that money as soon as they sign, right, in their pocket. But I've seen that second part work quite well in tandem with or in addition to that. But the judges will respect it somewhat. Anything that's in the contract, more is better. Control the risk, and that's just using your spider senses, right? Don't try and stick handle and juggle this stuff. You've got, especially at this brokerage, you've got a wealth of resources. And again, sometimes if you're not comfortable talking to the resources right away, go talk to a senior colleague. When I was a young lawyer, I used to go and talk to the kind of senior associates or junior partners before I'd go to the big scary, managing partner. Just because I felt unsure about something or had a question about something. Use the resources. Use the online stuff. Check something out. And Wes McMillan's article in Legal Update on oil tanks. There's a lot of stuff that you can check out, before you have to give some definitive answer. Know the property you're selling. That's an obvious thing. You only have to know it to the extent that's reasonable and the board and council expect you to know it, but you better know it to that extent. If there's any red flags, you got to track these things down. Again, someone wants you to put in the brochure perimeter drainage done 3 years ago and hands you a bill for $300. Pretty safe to say the perimeter drainage wasn't done, it was cleaned. Don't make a representation without verifying the source or being certain of it. Now, it's really hard in the MLS listing sheet, which has about 70 items, right? Number of parking spots. When you add up all the little bits on an MLS listing sheet, but that's why it's important there's a disclaimer at the bottom, and you get the folks to initial that. You get them to initial everything else. So they can initial that, the title search, the contract, all the PDFs, sign and initial. That way it's clear they got this. But when someone wants you to say some Herculean representation, like the roof has a 50-year warranty. Well, I wouldn't say that until I saw the warranty papers. And I'd want to know when that 50 years started as well, right? Keep good records, that's obvious. Be thorough, that's obvious. Know who you're acting for. Now, as a young lawyer, I took any file that came in the door with a retainer because I couldn't afford to not take any file that came in the door with a retainer check. But once you get past those first couple of years, if your spider senses are going off, if the first question in your interview with a buyer or seller is, how much is your insurance? You know, if your spider sensors are going off, you know, maybe you're too busy to act for that person, right? Or maybe you're just not the right fit with them. Maybe someone else will be. Because there's difficult clients, and if they want you to do something that you don't want to do or that's unethical or that you shouldn't do, like not disclose something under 5-13 of the rules, not disclose, you know, some electrical problem, say, you know, I'm going to get it fixed before closing. Let's not just put that down on the PDS, okay? I'm aware of that electrical problem, but let's not put that down. No, and have them reconsider. Maybe they want to talk to your manager about it or something, but then don't act for them. It's not worth it. Know your limitations and respect your limitations, because some people know them, but they don't always respect them because they were a roofer in the past. So they feel confident in saying, yeah, this flat roof looks good. Looks like it's been torched or something in the last 5 years. It looks solid to me. Don't say that, because they're gonna, if something goes wrong with the roof, for sure you're gonna be on the hook, or they're at least gonna come after you for it, because they'll say, well, yeah, I didn't know you were a roofer, or I didn't know, think you were a roofer at the time, but you told me you were 12 years ago, and you did it your whole student time, and you told me this roof was solid. That means a little more than you know, someone saying who doesn't have that background. So you're not a roofer anymore, you're a realtor, so just stick to realtoring advice. And again, fire difficult clients, it's really hard to do. But imagine, I mean, 18 months of listing a property where for someone who wants it listed 300 grand above where it should be, wants you to do an open every single weekend, you know, eventually you have to make the tough decision and make your business call and talk to your managers about it, about firing these people. Because they're just, you know, it's 2% of your clients that are going to cause you 80% of your grief, right? So it's being able to recognize those people. Use the materials available. Dual agency form is a good one. If you're doing dual agency, a lot of people are doing designated now. Buyer's agency agreement, that's a really good one I already talked about. And obviously if you're a seller, maybe use the PDS, maybe you don't. If you're a buyer, you insist on it at all times. But you gotta also make sure your buyers understand those preamble to it and the 3 disclaimers in it, right? If I was selling my house, I don't know, or know, is going to be answer to a heck of a lot of stuff, right? I don't know anything about it. I'm not a contractor. I don't know whether there's asbestos in it. I don't know any of this stuff. So all I'm saying when I'm filling that out is that I'm not currently aware of a problem with leakage or electrical. Doesn't mean there isn't one, just means I'm currently not aware. And you know, I've had people bring lawsuits and say, well, I was relying on the PDS. I didn't even have an inspection. I didn't have this. And those people do tend to lose their cases. We have pretty strong case law PDSs. But they still do it, and the person who ends up being in the firing line in that case is quite often the buyer's agent for letting them rely on it in that fashion, or not telling them to get legal advice on some disclosure issue, or who knows.
Hey, Chris?
Yes.
I guess a few years ago, Jennifer Klee wrote an article on relying on a property disclosure statement, and it basically is just a representation. It's no guarantee, and
Yep.
a lot of agents, probably none in this room, but a lot of agents feel that it is some sort of guarantee.
It actually says it's not a
No,
guarantee.
but people lie too.
Yeah, well, I remember that article because it was right when it was around when I started, because I was at Hartford Gray downtown, and it was right when I was coming here. And I actually am doing a PDS chapter for Legal Update 2016. That's right. So it hasn't come out yet. And so I had to kind of address those issues head on. And it is what it is. It's a tool of negotiation. It says what it says, and the courts are very literal. And it says this is not, or this is a starting point only. A prudent buyer will investigate all matters of importance to them. It recommends an inspection. It has a general disclaimer, and then at the bottom it says the realtors and brokers involved do not warrant or guarantee any of the information in this. And the courts have been pretty literal with that. And they've also said that some of them are about current. Are you aware? Are you aware? Are you aware? There's a couple of old ones, like has there ever been a grow up? There's a couple ones that call for you to go into the past, but they're very literal. And I guess the other thing is make sure that your client fills it out with their initials, not checks, and not you. Because then they'll say that you were the one filling it out, or you were the one recording the answers, or they have to fill this out. But it is what it is. I mean, I call it in my article that's going to come out the beginning of a discussion about the property between the buyer and the seller. And it's a representation, but it's not a warranty or guarantee, and that's been found repeatedly by the courts. Yeah.
Chris, I wonder if you could address the, commonly seems to come up now, where you have two, sometimes three people on title, and one person initials and signs off. Like that's the dad who does all the work and knows the house, but the wife says, I don't know anything about the house. Is that an issue, or should it be an issue out there, as long as one person on title fills it out?
Well, not really. I mean, what they do have, though, is they have multiple spots at the bottom. So the answers can be initials. I've seen how many initials can you fit into one box in the answers is, I guess, a limitation, and how many you can fit at the bottom. But I've seen multiple people initial them on behalf of sellers. I mean, buyers have to initial at the bottom and at the end as well. But no, I mean, they are what they are. And whether there's the dad signing because he's the head of the household and everyone else is just going along for the ride because they put it for business reasons or something in the wife and both kids' names or something. It's whoever signs it, it's their representation of their current knowledge. But again, if you get someone like me, I don't have very much current knowledge of the house. You know, I paint some rooms, I maintain it, I vacuum, I don't know anything about what's going on inside the house. The boiler could be crap, tons of things couldn't work. There could be mold in the walls, and I don't know about it, but I'm gonna say, I'm not aware. I'm not aware.
But there are some questions in there where you can't do that.
Well, then you should say, I don't know.
But
People don't use the I don't know enough, and I don't know is a good answer sometimes too.
There are questions where you can't do that.
Yeah.
You know.
Well, and you can also stroke through it. Your obligation, I think, for listing is to have a PDS, which means it can be a blank one because it's an estate, because it's tenanted, because the people don't know anything, because they're 93, even though they've lived there the whole life, they still don't know anything because they're now senile. Who knows? But you don't have to fill it out.
But I've had buyer's agents act like bullies because they've got seniors and they just drew a line through it because they really don't know anything about the home.
Well, they shouldn't be upset about it because they should still be recommending an inspection, which is going to cover off most of those things anyways. I mean, that's just a person who's not appreciating what a PDS is and what it's for and what weight it has. I mean, there's some people who don't want to do it. Ontario, they don't use them in many cases. The recommendation there, I think, is in many cases not to use it at all. And with bidding wars, they'll just say, nuts to you. If you're getting one, it's a blank one or a stroke through one. But, if you can still have an inspector, even on a bidding war, you can bring them in before you make the offer. Usually there's a window that'll allow you to trot someone through and get an inspection done. I think it's the same $400.
Chris, can you talk about the statute of limitations?
I can. It's pretty complicated stuff. It was until summer of 13, 6 years from the time of the oopsie that they had to sue. It's now
From the time of the what?
of the error,
Problem.
Okay.
the negligence, the oopsie,
Okay.
the alleged oopsie. From summer of 13 onwards, it's now 2 years, so it's a lot tighter. The difference, though, and the problem is, I might put it in my defense in many, many cases. Hey, this is from 8 years ago. My January trial it was 11 years from the time of the purchase before they complained. But it's governed by all these limitations, no matter what, it's 6 years, 2 years, are governed by what's called discoverability. So the time of the 6 years and the 2 years limitation period does not start to run until it's reasonable that someone in those circumstances would discover the error. So I might not know that there's asbestos in there or that there's rot in the wall or the beams are all rotten until I renovate the family room, which might not be for 11 years. So from 2011, I didn't even plead the limitation periods in that case because frankly I knew that they didn't find it till 11. I think I did anyways, but I wasn't that serious about it. But at the end of the day, their 6 years started to run from 2011. So they ended up with 17 years from the time of the error. Because I could only have been negligent during my involvement in the sale, right, which was in 2000. But it starts running when they discover it. So that's why people keep your documents as long as you can and should, and
I think
counsel
Mark
your...
Langdon said the last legal update 15 years.
Yeah, there's an
Not
ultimate
that long
limitation
documents for
period of
15
15 years. But the other thing is with technology today, I've had a couple people on really old files where they'd actually scanned it in before they destroyed it, so at least I had the copies. And sometimes the deal is only like 40, 50 pages. It's certainly not anywhere near as Herculean as keeping the hard copies forever. But sometimes before you destroy it, You can scan it in, or we have ones where we close them, but we know there's still outstanding litigation. We just close it because someone's died or they've moved off to Calgary and they're not interested in the litigation. But because there's ongoing litigation, we'll put do not destroy. But if it ever came to it, those do not destroys, those ones we scan in. So if we eventually do decide to destroy them, we at least scan them so we have the papers. And the judge might say, well, those aren't originals. We say, well, Judge, I've given you the best thing I can get because it's 16 years or 15 years down the
Chris, in
road.
regard to the limitation, if we were to receive a nasty letter from a lawyer, and 2 years elapses between the time we get the nasty letter from the lawyer, we're home free.
Well, you're not home free because they can always still sue. Anyone can sue anyone for anything at any time, right? I could sue Alan for wearing a purple hat right now.
Mhm.
He's obviously not wearing a purple hat, but I can still bring that lawsuit against him.
Right.
He would just have to defeat it. And in this case, what we would do to defeat it is we bring an application and say, well, this should be dismissed because they wrote a nasty letter and then sat on it for 2 years. And after summer of 13, it's 2 years, so you're done.
Perfect.
But it's still up to the court. It's a mandatory act, but you'll have a few judges who are sympathetic or something. If they can find some reason or some discoverability argument, they may try. But yeah, typically now it's a lot faster once you get that lawyer's letter. And I even write them back and say, we're not going to pay you, go jump in a lake. And then it's 2 years. Yeah, it's certainly pretty close to done.
We've got about 5 minutes.
Okay.
Just if you're.
Yep. The hold harmless clauses. California is allowed to exclude negligence and liability. I think it's California and a couple other states. We're not allowed to do that. Canada and the British system doesn't let professionals contract out of their own negligence per se. And home inspectors might face that once they start to, I know they're forming associations and that, once they become seen as professionals at some time down the road, it may be the court starts to knock down